Hi, my name is Nicole Hemrick, and I'm the managing attorney at Hemrick O'Malley, PLLC, located in New York City. Today, I'd like to answer a question from Fazila in Brooklyn. She asks, my husband abandoned me. Can I apply for a green card by myself? Well, abandonment by itself doesn't give somebody a right to self-petition for a green card. However, in these cases, there's often more than meets the eye. What I mean by that is, if there has been abuse in a marriage, you may be able to self-petition. And abuse can be a lot of things. Some people think it just means that there has been physical harm during the marriage, but abuse can be a lot of things. It can be threats. It can be emotional abuse. It can be damage to property. It can be harm to another individual. Sometimes there's a third party that's involved that is doing something harmful. So this is an issue that can be explored in discussions with an attorney about whether it will qualify. The rule about applying for a green card on your own based on abuse is under the Violence Against Women's Act. One of the questions I often receive is, can a man file under this act? Yes. Yes, it is not gender specific. Now, let's talk about the requirements a little bit. First, it has to be a legally valid marriage. There is a little bit of wiggle room there because there are circumstances where, because of the abuse, it turns out that the abusive spouse, who, by the way, must be a U.S. citizen or permanent resident, actually lied about already being married to somebody else. In that case, if the person being abused did not know that there was a pre-existing marriage and believed that they entered into a legally valid marriage, you could still proceed with the self-petition. Also, during the marriage, you have to have lived together within the United States. We already discussed the fact that there must be abuse and that it can mean a lot of different things, and it's worth discussing. And the person applying must demonstrate good moral character. What is good moral character? It's more about demonstrating things that you haven't done. So you want to have a clean record, no arrests. There are circumstances where there could be an exception to this if something the abuser did caused you to be arrested, for example. Another important fact here is, a lot of times when people are in abusive relationships, it is very difficult to gather evidence that you were in a good faith marriage, which is something else that must be established here. Generally, for a good faith marriage, we show things like proof of joint residence, proof of commingled assets, photographs together, proof of trips together. But in an abusive relationship, there are times where the abuser might withhold a lot of things that would otherwise permit you to give such evidence, or may not allow you to participate in life, such as getting joint accounts or being on a lease. In those circumstances, that might still be okay. We have plenty of cases that are like that, and that is a situation where, in a personal statement, which is always provided in these kinds of cases, you explain the lack of evidence and you give what you can. Maybe you can get statements from a witness, for example. Additionally, another important fact here is, if you do not want to be married to the person who has abused you, or you have already divorced the person that has abused you, you could still proceed with this case as long as you file before it has been 2 years from the time the divorce was finalized. So that is an important deadline to keep in mind if you are thinking of proceeding with this sort of case. If you believe that you have been a victim of abuse and would like to apply for a self-petition, please give us a call at 833-848-7838, and we'd be happy to help you. Be safe.